There's simply some things that an executor cannot do during a probate sale. Being named as the executor of someone's will truly is a great honor. Clearly, the person who named you obviously trusts you implicitly and actually believes that you could handle the settling of the estate. Yet even the person who passed away didn't realize the extent of the work that's involved in settling their estate. You have now taken on a variety of responsibilities. Some tasks are more trying than others. Some of those tasks include notifying the heirs, collecting and compiling any assets to settle the debts of the estate, file estate tax returns where necessary, sell the house and ultimately distribute the assets, and finally close the estate. However, an executor does not have endless authority, and there's just some things an executor cannot do during a probate sale. First, let's understand some of the things you must do as an executor. Once the court gives you the authority to act as the executor on behalf of the decedent's estate in what's called letters testamentary in California, or simply letters, you can now start executing the settling of the estate. Your first duty is to notify the beneficiaries, financial institutions, and any other known creditors that you will be acting on behalf of the estate and settling it as soon as you're able. At this point, you, the executor, will be responsible for managing the estate's assets. That sounds pretty straightforward, but it really all depends on how complex the estate is and how organized your loved one was with the paperwork. As a side note, you'll probably come to the realization after the estate is all settled how important it is for you to personally employ good record-keeping practices, and even more importantly, to invest in a well-constructed living trust so that your loved ones can avoid the painful process of probate regardless of the size of your estate. Now, as the executor, once you secured access to the assets of the estate, you can now liquidate any of those assets to pay the associated debts. But remember, this doesn't give you free will to handle it however you want. Two rules that you must always abide by is that you must always adhere to the provisions set forth in the will, and you must always act in the best interest of any and all beneficiaries. Don't deviate from these two rules and you'll be doing just fine. Once all the debts are settled, including the sale of the home, your job will be now to distribute those remaining assets according to the terms established by your loved one and the will. One of the most common challenges I see executors face is dealing with the initial security of the property. By that I mean changing the locks to prevent anyone from accessing the property. Why this is a challenge for you is because it's extremely common for family members, friends, and even unrelated parties to descend on the decedent's home immediately after death so that they can rummage through the home and get first crack at heirlooms and jewelry, cash, collections of all sorts, precious metals, and other valuables that might be in the home. So the solution would be to immediately change the locks and personally check all entry points to make sure that they're not accessible, and then post a notice on the door that says something to the effect that access to the property before the court orders are issued may constitute a crime. But in this case, you're kind of stuck in a little bit of a dilemma. Maybe you already know that you have been chosen by the recently deceased in their will to manage their estate, but until the probate can confirm those wishes and issues those letters testamentary, you probably have no authority at all. According to my own personal understanding, you cannot take any action to manage the estate prior to being appointed as the executor by the court. And the process to get issued letters testamentary saying that you are in fact the appointed executor can take quite some time depending on how busy the court is. It could take weeks, and it could even take several months. In the meantime, the estate may be losing assets. So if I were you, I would immediately contact your probate attorney and ask them if you can go over and secure the estate right away and the right way to do it. If you need access to a probate attorney right away, reach out to me. I know some of the best probate attorneys in Orange County, California. Managing the estate means that you will make many decisions about what will happen with the estate alongside with your attorney until the estate is fully settled and closed. Before we get into what an executor cannot do in a probate, let me briefly introduce myself. My name is Anthony Nitz with eXp Realty in Orange County, California, and since 1997, I have been helping people just like you maximize the value of any probate or trust-related real estate and doing it very quickly. If I can help you in any way, just reach out to me anytime. While the executor has a final say on all matters, there are still limits. Again, you cannot take any action to manage the estate prior to being appointed as the executor by the court, so be careful about that. You now have what's called a fiduciary duty to the beneficiaries of the estate. What that means is that you are now legally obligated to act in good faith and solely in the best interest of all of the beneficiaries of the estate, regardless of whether you're a beneficiary yourself or not. This is a big responsibility. So in other words, you cannot do anything that doesn't act in the best interest of the beneficiaries. Also, you cannot sell any of the assets for less than market value without all of the beneficiaries in agreement. I would suggest you get any such agreements in writing, just in case there's a dispute later. For example, selling that $25,000 car in the garage to a friend or family member for $5,000 would be in direct opposition to your duty. This applies to anything of value. Another thing is that you do not have the authority to change any provision in the will. If you feel a change is necessary, well, discuss it with your attorney. And as an executor, unfortunately, you cannot stop anyone from contesting the will. And this is one of the reasons why I practically beg and plead with people all the time to get a living trust right now. If you need a good attorney to write that up, just let me know. Just remember, mismanaging an estate has consequences. If one of the parties believes that you are not fulfilling your legal obligations, they have the right to file a petition with the probate court to request a full accounting of the estate or to have you removed as executor. Of course, most individuals who serve as executor take their responsibilities very seriously and they handle the estate with great care. However, one of the biggest drawbacks to being an executor is the significant amount of time to take and properly handle the entire process. For example, consider the time involved in contacting various government agencies to stop any Social Security payments, or contacting the IRS or the state tax authorities for income tax and possible death tax. Then handling the personal property plus selling the house. A good probate attorney may help with some of the responsibilities with taxes and Social Security benefits and dealing with the courts, so don't be afraid to ask them. And a good real estate agent who is very familiar with probate and trust sales can help simplify the process of preparing, marketing, and successfully selling a decedent's home. By the way, be sure to ask us about our free clean out service. Did you know that when you hit the subscribe button and the like button, it helps this information get distributed to more people like you who may need to hear it? Also, if you have a specific question about selling a home in probate or in a trust, reach out to me directly. We'll get it answered for you, and it'll likely benefit others because, well, we'll probably make a video answering that question. And if you asked it, there's probably others who would like to know the answer too. We have other great videos popping up on the screen now, so feel free to watch or browse around our channel to see if we've already addressed your question. I'm Anthony Nitz, the probate agent with eXp Realty, putting the pro back into probate.